All right, everybody. Thanks. This is the last series, wound care compliance. So we're bringing together all of the stars of our past episodes. I'm very excited to have everyone together today, get some great interchange and discussion. We got a lot of questions from the audience, past webinars, and also we put out a special request for this. So we're going to let the panel take a crack at your questions. Just to briefly introduce everyone again, Ronald Chapman is a nationally recognized defense attorney with an unmatched record of trial victories in healthcare fraud and reimbursement cases, and the president of the Safe Harbor Compliance Group. Katie Fergus is the president and owner of PractiSynergy, a medical billing and consulting firm that specializes in supporting independent medical practices with customized revenue cycle solutions. Dr. Dan Kapp is a board-certified plastic surgeon and nationally recognized expert in wound care management and wound care history, honestly, and using advanced biologics and innovative technologies. He is the CEO of Mednac, an audit expert consulting firm. David Traskey is the co-head of the Washington, D.C. office of Garfunkel Wild, a nationally recognized healthcare law firm. He focuses on fraud and abuse matters, compliance strategy, and government investigations and audits. Michelle Lerma is the CEO of Rogue Medical, which offers over 50 years of combined wound care expertise and provides comprehensive resources to optimize your practice. And we're also joined by Venture's own John Schroeder, our CEO, who's going to answer some questions about what the hell is happening with the PFS and the LCDs and what we see as the path forward. So great to have all of you here. Thanks again for doing this. I think this is going to be really great. As we discussed, I'm going to kind of direct the questions, but please feel free to refer them to others. I may do that as well, get several different perspectives on some of these. So to start off, we're going to kind of talk about billing, coding, and compliance. The first question is for Katie Fergus. Our state doesn't have a current LCD that limits the number of treatments with skin subs. Will the new LCD get us in trouble with an audit in 2026 for exceeding the limit and going into 26 with additional treatments? Katie, you want to take a crack at that one?
I will take a crack at it. So obviously the new LCD has not been tried or tested yet. So I don't think any of us have the absolute answers on that. But in our opinion, I would say yes, they're going, likely the auditors and the individuals looking at the documentation are going to look at the full treatment period as a whole, regardless of when it started. So I would abide by the new LCD guidelines as you enter the new year here. You may still, as the LCD is written, you can still treat a patient using the products and whatnot that you are using now. It will be grandfathered in under the new LCD guidelines. But again, I would kind of restrain the since your area does not have an active LCD policy, I would obey the guidelines given by the new one for length of treatment. But always open to other opinions on the panel here.
Well, I think we think it will be by date of service, right? Although they're trying to apply the darn things already, but it's supposed to be by date of service. Is that right? Anyone disagree with that? I think we've got agreement. Okay. So another one for Katie. This was an interesting one, I think, and there may be some opinions from the panel about this also, but how should we document instances where a patient refuses components of conservative therapy but meets the other criteria for grafting? What should you do in that situation?
Yeah, I conferred with my certified coders on this one and the ones that really look into the documentation. And currently, the LCDs specify that to have a failed to if treatment has failed, it must show evidence of healing within the 4 weeks of conservative treatment. And so there's aspects of that conservative treatment or standard therapy specifically listed in the LCD policies, whether it's infection, edema control, offloading, compression, etc. So in our opinion, if there's any areas of conservative treatment that's being refused, we're not the medical, we can't make that medical decision as to whether a graft should or shouldn't be put on. But in our opinion, it should be documented that there is a refusal and discussion of the alternatives have been presented to the patients.
Great. Anybody have other thoughts to add to this? All right. Dr. Cap, what documentation is required to justify grafting in the presence of tunneling or undermining? And how do you assess clinical appropriateness in those scenarios?
So that's a really good question. If you go to my LinkedIn and scroll through my LinkedIn posts, you'll see that I wrote a LinkedIn post about wound surface area. And wounds are not a length times a width, because some wounds are circular. When a wound is circular, you actually have to measure the area of the circle because it doesn't have a length times a width. You really should measure the area. And really what you need to do is look at the surface area of the wound, and you need to report the surface area of the wound, not the opening of the wound. And what I see a lot, and I think the attorneys can probably chime in a little bit this, but we see the error that people make is they will take this circle here and they'll say that's the size of the wound. But what we really want to look is the surface area of the wound, not the circle of the wound. And if you do that, you really get a better measurement of the wound. So take a can, cut off the top of the can, and you want that internal surface area of that can. And I posted that. If you look on my LinkedIn, I think it's really important to understand that that's the proper measurement of a wound, is the surface area of the wound, not the length times the width times the depth. You can put the depth, but you have to have the surface area of the wound.
Good thoughts. Anyone else on that one? All right. This is for Mr. Chapman. How do we ensure personnel maintain of compliance related care?
Well, that is the question, isn't it? I've got to tell you that after talking with a lot of wound care entities and wound care providers, it's surprising the number of them that do not have a compliance program in place that includes training of their staff to ensure that there's compliance. Oftentimes we see people have a compliance program where they just basically printed off something from the internet that they found. And I will tell you that's going to be exhibit number 1 if the DOJ comes knocking. What you really need to do is make sure that it's tied to operations and make sure that it's trained with the staff. And then you audit, monitor, and ensure that if there are any shortfalls in compliance, those are very quickly addressed. That's much better than doing the ostrich approach and sticking your head in the sand. So training, going to webinars like this, obviously very helpful. And then, getting an expert on board for some chart review to make sure that wound care compliance is definitely kept up. Very helpful. I think that those approaches will serve an entity well when it comes time to respond to an audit or an investigation.
Great advice. Okay, Michelle, what level of clinical detail is required to substantiate medical necessity for repeat applications beyond the initial 4-week window? And I know you're going to tag in a friend here, so
Yes, just because as a distributor, obviously, I can't practice medicine. I can always refer you to the guidelines, LCD, wound care LCD. That's very, very important. But the clinical detail that is required is, what are the basics of wound care to begin with? What is the wound care LCD state is a requirement to meet that medical necessity to move to any advanced modality, whether it's a skin substitute, whether it's ultramist, whether it's PRP. Those basics have to be completed. So if you're going through your series specifically with the changes that we're all going to face with this new LCD, it is critical to show an improvement in that wound bed. So what does that mean? Has there been a change in exudate? Has there been a change in smell? A change in edema? What does the wound look like? Is there an improvement in granulation tissue? Not just size. Size isn't always in itself improvement. all of those other factors contribute to an improvement in that wound, and it has to be documented in detail because every single piece of that visually attributes to the progression of that wound. I want to refer this actually over to Dr. Cap from the medical side to be able to answer that probably a little bit better in detail.
Yeah, I think the key is you have to document. If you are using a therapy and the therapy is working, you have to document the therapy is working. The challenge is, when is the therapy being applied that is a non-productive therapy? In other words, the patient is not benefiting from the therapy. We know sometimes when we apply the grafts, it takes a couple of weeks, maybe 3 weeks, for us to see a beneficial change. But we have to have a documentation of the improvement of the wound, that the wound is not, that the treatment is not futile. So it's really important to document that. And then it's also really, really important to document that we have a goal for the therapy, so that the reviewer says there is actually a goal here and a target. And there may be some legal points that the attorneys want to, address, but that's how we look at it.
Okay, Ron, David, anything to add from the legal side?
I mean, I think he said it just fine. The beauty of this area is that we have a lot of experts, such as Dr. Cap, who know the LCDs quite well, know what's required because you've all had to defend it quite regularly. And as a lawyer, it makes my job a little bit easier when folks have done that sort of research.
Yeah. And I think just to highlight what Dr. Cap was saying earlier, I mean, length times width may not be the only thing to look at. In fact, it may not be very telling at 4 weeks. So you want to be using other tools so you can really see what the area of improvement is. And it may not be the opening size. So something to keep in mind. What tools to use. Okay, for Katie Fergus, what if the provider completed the 4 weeks of conservative care in a clinic attached to a hospital and is now following the patient outside the clinic and billing from a separate entity? Does that meet the 4-week standard of care requirement?
Yes. So as long as there's documented, as long as there's thorough documentation on what has been tried, what has been failed, it meets all the other specifications within the LCD guidelines in terms of failing treatment within a facility. Yes, treatment may be moved to an office or other setting.
Great. Michelle, are there any limitations on graft wastage, and how should you document wastage under the future effective LCDs?
So as of this moment today is going to be no different than when that LCD goes into effect. This is very, very important. You have to use the most appropriate size graft available based on the size of that wound. So this is a little challenging in that some manufacturers may produce only a 25 square centimeter wound graft. If that wound's 1 square centimeter, you're documenting with your JW modifier 24 units of wastage. Be prepared. You will probably get audited with that what appears to be overutilization from an auditor standpoint. But to answer that question specifically, you want to use the most appropriate size graft based on that wound size. So if that manufacturer provides you a 2x2, a 4 square centimeter graft, there's no reason for you to order a 4x4, 16 square centimeters when there was a more appropriate size to use. So what happens today should continue into the new LCD with an understanding of the importance of overutilization.
Thanks.
Can I add to that,
Yeah,
Howard? Do you mind? Add to that, because it's really important. So what we see in the audits, and Mr. Chapman and Mr. Trasky, they can validate this as well, which is that providers have been reporting zero waste and folding the grafts over like this. If you fold that graft over, that is excess. There's nothing in the package insert for the product that says you should fold the graft over. So please don't fold the graft over. If there's excess product, remove the excess product and account for it. I know it's much easier. I know that they reimburse for the size of the graft that was purchased and applied. But if you're folding it over and you're not reporting it, and Katie, if you could explain that a little bit, because it's really important. And I know that people should know this at this point, but it is a sticking point. Can you explain that? I think that would be helpful for people.
In terms of a documentation perspective?
Yeah, I think that's what he's asking.
Oh, yeah. So
Yeah.
we definitely, I 100% agree with Dr. Cap in that respect that our coders educate our providers to truly document what they're using, remove whatever excess, and don't use it for tunneling. Don't fold it over. Don't, jam it in or anything. Just truly, it's a surface barrier. I mean, it's a wound barrier. And I think I sat in on Dr. Cap's other webinar with Venture here, and he talked a lot about using that terminology as well. And so we've had to almost re-educate our providers that it's truly a barrier. It's not meant to be folded over or kind of stuffed into the wound. And it needs to be documented as such. And absolutely, 100%, we tell them you can still be reimbursed for the waste, but you need to document it appropriately and have pictures as such.
Great. What about wound photography? Are there specific standards of wound photography that you need to withstand audit scrutiny?
I'll take this one. So we would definitely recommend a timestamp, having the size measurements with a wound tape in the photo, a site identification and patient identification being required. That's usually what we recommend to our providers. I would definitely love to hear what the attorneys and those that are dealing with the ALJ hearings have to say as well. Is there additional information besides timestamp measurements, site identification and patient identification required from a legal perspective?
Yeah, I mean, I think that all of those things are correct. And I would say as a practical matter, make sure you have the photos and that you submit them as part of any type of appeal, because sometimes we see providers who provide records, but they don't provide the photos, or they don't timely provide the photos. And so then that creates, a separate issue. But I think those are the things, those things that Katie mentioned are the sort of the key points. And then obviously, just as like any good photograph, right? The clearer, the better the quality of the photo, the better it will be in the long run.
And to second that, also in color.
Yes.
Because sometimes if it's, if you're faxing documentation, or if depending on how you're submitting your appeal or your audit, it gets really grainy.
So I'm going to jump in here real quick. I'm not a clinician, obviously, but from the human side of things, a lot of these questions are related to an outcome together. And what I mean by that is we're talking about, people asking about undermining and tunneling. People are asking about how do you measure the wound surface area. And what I've seen a lot in the field is a wound opening that we use a really great newfangled camera to auto measure. And that opening might be, say, that big. But then the undermining makes it really that big on the surface area, or a tunnel goes up, 11 o'clock and adds another 6 square centimeters. And I think it's notable to say that what Dr. Cap is saying is the barrier is protecting the whole surface area, which means the bottom of that tunnel. It also means the bottom of the lower part of the wound that is not the same size as the opening. And if in fact the topography of the wound bed is not just like a can, like he mentioned, but there's some rounding to the bottom of it, you have to account for all of those things and document it. Now, if you don't want to throw away or the product that's folded over, you're just talking about the utilization of the product that's on that surface area that you can actually measure and quantify. but all of those questions kind of play together. And so the more you can talk about this wound, the human aspects of this wound, right, the individuality of that wound in your chart note, the better you can document why you're using what you're using, and it makes a lot more sense.
You know, John, I want to, elaborate a little bit more on what you said, which is on the automated digital photography. Oftentimes, it's actually quite wrong, and in surgery, we're not using AI for surgery. If anything, we'll use virtual assist, but we're not using AI for surgery. I think that there's a little bit of over-reliance that the AI is correct. And when you can visually see that measurement does not correlate to the image that you are looking at or the patient that you're physically looking at, you need to correct for that. And we have a couple of cases where people are now running into trouble because they just automatically assume that the measurement provided by the software was correct. And clearly, when you look at the images and you compare them with the measurement, you can see that there's a disparate, because it does not account for all the topographic features that you have in a wound. So I think that's a really good point you raised, John.
Yeah, a good point. And most of these systems, they rely on you to manually input the undermining and tunneling. Like, they don't automatically pick that up. They're measuring the inside edge, whatever big that is. They're not getting into the depths of it or figuring out other things. And so if you're using one of those systems, you have to, manually call out the undermining and tunneling. And they're not great as to how they work for that. I guess it's the best we could do right now, but it's a little clunky, honestly. So just remember to do that. Or when Dan's trying to testify that you did the right thing, he doesn't have the documentation to show that in fact that wound was 30% bigger than it looks like on the initial photo. So give your lawyers and your experts a chance. Okay, Katie, a little kind of ad here maybe, but this person asked, they're currently seeking new billing services. Can you briefly provide questions I should ask to determine if the biller is equipped to properly bill for biologics?
Yeah, good question. So yeah, little plug for PractiSynergy here, but I would say any good biller out there, you need to make sure that they have experience billing camps, biologics products, etc. So some good questions to ask are definitely, do you employ certified coders? You want to make sure, and not just certified coders, but coders with experience in wound care. And then how familiar are those coders with current and upcoming LCD, NCD policies on biologic, as well as the commercial advantage plans out there. Another question, on average, how many biologics are you billing for monthly? If it's, hey, I have one podiatrist that does one that has a patient about every 6 months, that biller isn't going to be as experienced as someone like, I'll just say PractiSynergy, who has 50 different clients, who, although the individual providers may only have 1 or 2 clients at a time using CAMPS products, we have 50 of them. So again, it's volume. So my coders are getting real life experience. They're keeping their skills tuned. They're getting trained. They attend trainings such as these webinars and other like SAWC conference. They try to go get as much information as they can to stay up to date. Another basic question is obviously, what do you charge? And what's your fee? What's your denial rate and your clean claim rate? Some of the denials that are out there, we get when we're getting a new client coming to us saying our biller doesn't know how to bill skin grafts. We look at those denials and they're simple. Maybe it's a split claim that didn't get appropriately billed with line notes and a 76 modifiers such as that. And so to us, that's easy fixes, but they really should have been billed correctly the first time, which obviously delays payment to everyone involved, everyone down the whole pipeline. And I think one of the last questions I would ask is to the billing company is, what is your process for appealing those denied claims? What type of expert support do you use? Who do you tap into to really get the best appeal process that you can get and be successful at those appeals?
All right, great advice. This one's for Dr. Cap. There's a mention in the PFS of products that are actually 351. Are there any skin subs for chronic wounds that are actually 351?
Howard, you're the one who knows that.
Yeah,
I
there's
really
one.
don't-
It's
which one is it?
and it's not for wounds, it's for burns. So
It's for burns only, right?
Yep,
Right.
burns only. So as far as I know, the answer is no.
Right,
So
right.
it has either a 510K, a PMA, or HCTP. No one has a 351 for this
No, there's one
indication.
351. There's one 351 that but it's not a graft. It's exosomes that they're in clinical trials now. So that'll be the first if it makes it out of clinical trials. And
but not
I don't know that it's going to make it out. I don't know that it's going to make it out.
Yeah. Yeah, nothing currently granted as far as I know, and as far as Dr. Cap knows. So take it for what it's worth. All right, we're going to move on and talk more about audits and appeals. I know that's a big subject of interest for people too. So I'll start with Dr. Cap from kind of not only his expert perspective, but as a clinician, what do you suggest is the best first step when facing an audit? Audit shows up on your desk. What are you going to do?
The best first step really is not to panic, because that leads to delay. And that's been the biggest problem that we see. I think probably Mr. Trasky and Mr. Chapman can tell you that the biggest problem that we have is that there's a degree of shock involved in receiving the paperwork, and it leads to delay. But the best way to do it is to develop a checklist and a spreadsheet of all the documentation that is required, and methodically go through that checklist, because the best way to obtain a good defense of the audit is to be well organized with the documentation that you provide the auditor, because that initial documentation is the basis for everything that takes place in your care, in your continuum through the audit program. I'm going to stop now. I think that probably the attorneys have a little bit to say about that as well.
David, you want to jump in?
Yeah. So I think Dan is right. As hard as it is not to panic when you get that notice that you're being audited, I think the first thing that you do is you take a deep breath. The second thing that you want to think about is, I always tell our clients, healthcare is a team sport, right? So on your team, there should also be an attorney, a billing and coding and documentation specialist, and then a medical necessity expert. And obviously, you want to try to have those people lined up before you need them, especially the lawyers, because the earlier you kind of just sort of take it head on and figure out sort of a methodical way to respond to what's being asked of you, that's going to get you further in the process than kind of sort of waiting to the last second, or kind of just moving through the process without any kind of plan, so to speak.
Yeah. Ron?
Yeah, Howard, definitely would like to respond to this one as well. There's a few practical tips here. First, I want to mirror what has already been said, but it needs to be said again. Don't go at it alone. That's been number one problem. I'm picking up cases that are past ALJ hearing where they didn't call an expert. I'm picking up cases that probably should have been appealed to a federal court. And here's the problem with starting to defend your audit and doing it the wrong way. The system right now is designed through a series of bureaucratic hurdles to basically win by attrition, right? That's what that's what they're doing to protect the program right now, is making it very difficult for you to ascend through these steps and protect your rights. And then you lose at some level, you run out of funds and they squeeze you out and you can't get reimbursed. And so you stop. Well, the problem with that is, if we're going to defend wound care as a whole, we can do it much better together, but it's going to come through an individual fight where one provider gets to federal court, gets to a judge, and a judge says that this new payment guidance needs to go bye-bye, that an administrative law judge has committed an error in a certain interpretation. So we're stronger together. And when you start your audit process, you've got to do everything exactly right from day one so that you can give your attorney and your experts the best ability to defend you. And maybe you will be that case that breaks through for everybody else and leads to a nationwide injunction, or leads to a case that can be cited that will give you a tremendous amount of relief. And that's really what we're looking for right now. We're hunting for the right case so that we can give relief to everybody.
Yeah. Can you guys explain, kind of carry on to this question, evidence rules about when you can put in evidence and when you're barred from new evidence? So can you guys, one of you explains kind of how that works and what the consequence of that?
Can I answer that from like the doctor client perspective?
Sure.
Because this is the most important thing that you need the attorneys for, because what I have seen is, and not only am I a consultant, but I'm a client too. So I've been audited also. So, and what I can tell you is we're all really smart at what we do as doctors, nurse practitioners, PAs, but we know when to refer things. And it's really important to understand that as smart as we are at reading, as smart as our reading comprehension is, as good as we think our care is, we're not lawyers. And you really need the lawyers, because it's the evidence and how they present that evidence and how they present the arguments is the most important thing. I am blown away by the technical nuance. And it's just like we can all treat diabetes because we all went to school, but endocrinologists treat it better. And it's really important not to have this negative attitude. The attorneys are just amazing. I'm just putting a pitch in there because it is really helpful. And it's, the earlier they're involved, the more masterful they are able to provide a defense. And I'm saying that from a client standpoint. So I want you to hear that from me.
And I second exactly what Dr. Cap says, and this is coming from a billing company perspective. We are also not attorneys. And so we have partnered with some consultants that help as early as the audits to help develop that audit package so that they can then start building the case at that audit level, and then continue on through the appeal letter. So again, agree with Dr. Cap on that. So I'll turn it over to the attorneys to talk more about that evidentiary aspect of it.
Yeah, David.
Yeah, I think that's right. So again, the earlier the attorneys are involved, the better it is, because they can sort of start telling the story, and they're able to do it in a way that resonates with the with the reviewers, the auditors, and ultimately, the judges as it goes through the appeals process. Howard, to answer your question, I mean, the best time to sort of create the record or start building the record is right when you get that first request from the UPIC that you've been told that you've been audited and you're being asked to produce records. But going forward through there, if you go through the Medicare appeals process, the first two levels of the appeal, redetermination, reconsideration, those are the times that you really have to build the record, because once you get through those first two stages, it becomes infinitely more difficult to introduce new evidence at the ALJ stage or beyond. You'd have to show that the evidence is new and material, and for whatever reason, it was not previously available. And as a practical matter, I would say, and maybe Ron would agree, that the judges are generally loath to be the first people to be looking at new evidence, if they can help it, right? So they want everything kind of neat and tidy when it gets to them. But yeah, so that's, after that, it becomes much harder.
Yeah. So I think pretty much in a panel that you need to on board. Don't save money, get screwed later. Go ahead and get people to help you, particularly if there's a significant. And no, just let amount of money will not make them. That will make you a target, right? It doesn't end just because you let them take $30,000. They're going to come back again if they think you're an easy target. Just to be straight about it. All right, Dave.
Howard, can you have the attorneys talk about that a little bit more specifically? I think that
Yeah, that's what I was
something
about
that
to say.
I have seen as a provider, and I think they need to talk about that, why you need to defend yourself and not pay back.
Yep.
Yeah, happy to jump on that one. First, I will say that the biggest mistake is buying that Ferrari. Like 100% of people I've seen criminally indicted for this have a supercar. So just be careful. Be careful about that. Not to make anybody uneasy if they got one. But on the serious side, it seems to be a habit. And a lot of lawyers are advising this who don't understand the space. In fact, I can't betray confidences, but I will say that just 2 days ago, I got off the phone with a provider who was led to believe from his high-powered law firm, AmLaw 200 law firm, that if he just paid back this amount, that this CID that he was delivered would go away, right? And that's hugely problematic because the last thing that you want to do is admit responsibility, pay back the system, especially when the initial audit was a probe audit, because they'll just request more records, they'll increase the amount, and they will realize you're an easy target. They can go and get more money. The other thing is when you lay down like that and you don't submit evidence, likely you're not going to be reimbursed. You're certainly not going to be reimbursed. And you're preventing a robust defense when you finally decide to get one together. So the example might be, I receive an initial audit overpayment demand. I don't fight it. I let it go. But then I get a bigger one and I decide to fight that one. Well, just understand that the fact that you didn't submit any evidence for the prior overpayment demand is certainly going to be considered later upon review. And so you're really prejudicing yourself initially. Going back to the evidence question, because I think it kind of ties into this, redetermination, the last real possibility you're going to have to be able to submit evidence in support of your case, while you might be able to do it at the ALJ hearing, it's incredibly rare for the ALJs to allow that to happen. And that becomes really, really important when we're deciding which of these cases to fight. My response would be fight every single one of them so that you can go through the appellate stage. And it doesn't have to be that costly as long as you get counsel who's done it before and knows the process, and you get a good expert who can testify. I think we've got a couple of good people on this call that would be able to help you out.
Great. All right. So for can you guys provide examples of successful audit defense strategies specific to skin subs? I mean, what's the strategy really?
David, feel free to jump on that one first, but I certainly want to chat about it after.
Yeah, go ahead, Ron.
Yeah. The best audit strategy is going to be patient by patient, case by case, showing medical necessity. One thing that's pretty important, Dan mentioned this, we've got tunneling, we've got areas around the wound that isn't necessarily seen in pictures. And so when you're just submitting photographic evidence, that's not alone going to be what you want to do. You've got to have really good documentation. So if I just had to lay it out cleanly first, make sure our documentation isn't cookie cutter. Submit photos, measurements. I would like to see that on the photos. If you have an independent medical review done of wound care treatment, that is going to be an added benefit when defending the audit. Making sure that we're complying with the LCD, even if it doesn't apply to you, is always a very good strategy. And then making sure that when we send our records response, in response to the audit, we're including every single thing. It's a mistake that I've seen made time and time again, where we're missing what records should be put in there. And then I would say, finally, in terms of really good audit strategies, we want to make sure that we're communicating in the best way possible with the auditor, meaning if there are additional explanations for the treatment that we provide, let's do that in a letter format, right? Let's explain why this patient needed it. John earlier on talked about the human side, and I wanted to touch on that as well. Remember, there are miracle stories that have come out of wound care treatment using skin substitutes. There are people who've been saved from amputations. There are family members who have a loved one who now has a second chance at life. There are patients who've been given a chance at avoiding an incredible amount of suffering. Those stories matter as well when we're submitting evidence, maybe not to the MAC, but they will matter later on. So why don't we submit the evidence of that as soon as possible? Family members in the informed consent, if they're signing it or maybe even making a statement about how this has helped their loved one, there really is a human side of this. And ultimately, we need to convince the federal government that they are increasing suffering by engaging in the tactics that they've already engaged in. And that's a case that I'd be happy to make in front of a federal judge.
Yeah, the other thing that I would add, in addition to what Ron has mentioned, is that I would even go a step before all of those things and say all of those things are very good audit strategies, right? But even before that, I think the best audit strategy is understand that if you're operating in this space and you have been for any length of time, it's not a question of if you will be audited, it's a question of when you will be audited, right? And so it's about being proactive and being thoughtful about what you say and how you say it, whether it's to patients, whether it's in your medical records, and certainly as you go through the appeals process, how you say it, in your submissions and at hearing before the ALJ, right? So lawyers will be the first people to tell you that words matter, and how you say those words and the context behind them also matters. So those are sort of in addition to the things that Ron was talking about. I think it's sort of vitally important to go into it with this mindset that if you're going to be in this space, then you may have to rethink, all of the things that you sort of have learned previously. And I think, Katie had mentioned that too, right? Educating providers on how to document things in the appropriate way. What sort of keywords are going to be in the medical records documentation that are going to be read in your favor, right? Rather than used against you in any sort of audit or proceeding. So these are all just very, important things to keep in mind as you move forward.
Yeah, from my standpoint as a expert, I need time, because I will go through every single record. I'll look at all the notes. The more organized they are, the more time I have. When I have more time, I can build out a cost analytics because I know the alternative procedures that could be done, and I know the downstream costs of those procedures, having done them over the years. But I need time to do that because it's individualized for every patient. And the more curated your response to the audit is, I think the better the outcome, at least what I've seen from a consultant side.
Good point. David, coming back to you. I know part of your answer to this, probably people don't want to hear, but are there red flag factors that you think tend to trigger audits more or less?
Yeah, I definitely think so. I mean, the list can be pretty long, but I mean, I think, look, the first two biggest red flags are the frequency of the use of a particular product and the amount of money that you are receiving, getting reimbursement. So if you are a frequent user of very expensive products and you are being reimbursed millions and millions of dollars, even if it's only for a handful of patients, those are the types of red flags that is going to trigger an audit. I would also say there's a tremendous amount. So I came from the OIG before I joined private practice. For many, many years, I was with the Office of the Inspector General at HHS. I will tell you there is a tremendous amount of data to which the OIG and other regulators to which they have access. And so they are also looking at things like, receiving patient referrals from providers where you have no prior relationship. So obviously it's, the relationship between referring providers has to start somewhere. But if there is a long history of referrals with no prior relationship, that's going to be a trigger for the government. Similarly, treating patients for which you have no prior relationship is also a trigger for for the government. In particular, if it ends up showing that you're using skin substitute or CAMPS products on the first visit. And then sort of more generally, what I would say is from the data standpoint, because that's where a lot of these cases are being, that's sort of the jumping off point for a lot of these cases is, what sort of, depending on what sort of the arrangement is that the providers may have with the distributors, the manufacturers, the sales representatives, the marketers, all of those things, that ecosystem and the referrals that go back and forth are going to be scrutinized, as is the compensation that changes hands. So looking at things like, what's the compensation? Is it fair market value? Is it commercially reasonable, right? This is a plug to make sure that if you're entering into contracts, and you should be entering into contracts, that those terms are laid out there clearly in the agreement. So if you ever have to justify what you've done to government regulators, you can point to the contract, right? Making sure that the compensation that you're receiving is not based on the volume or value of referrals or the work that you're doing. And the next sort of sets the next couple ones that I would offer you, these are just ones that I've seen. And these are ones that tend to sort of go the criminal route. But obviously generating medical records for patients that you didn't personally treat or you don't know, altering or modifying medical records to pass audits or to ensure reimbursement, generating 2 different sets of books or invoices, or any type of underreporting that might have to happen with respect to rebates or discounts or other financial incentives. And then lastly, just, providing care that's not medically reasonable, necessary, and appropriate. In particular, the care that stems from either kickbacks or prohibited referrals, or results from some sort of patient steering, or results in overutilization. So there are many.
Ron, haters coming knocking. But the question we got was, who do they talk to? Do they talk to the provider, or do they talk to billers, nursing staff, etc.?
Well, yeah, talking isn't the first thing they do, and I think David covered that quite well. They're going to do a pretty significant look into the data. Let me try to parse this out with a couple of different types of investigations or audits that might occur. Obviously, for most audits, the first thing is a medical records request. We're going to see that. When we're dealing with something that's a little bit more civil in nature, where the AUSA is contemplating a potential civil case, we might see the first thing be a civil investigative demand, which is basically a request for documents and potentially even testimony in some cases. If we start to hear about interviews, like actually knocking and conducting interviews, then we're likely looking at more of a criminal investigation that's occurring. Of course, it could be another form, but usually I would be a little bit worried about a grand jury investigation at that point. And the people that they will mostly talk to, first, generally, and I used to be an investigator and I prosecuted cases on behalf of the federal government. What I would normally do is start with employees who were no longer with the practice and chat with them first. If there aren't any employees like that I could maybe find that were disgruntled or maybe weren't tied or connected to the practice, I would then start to poke around some of the contractors that the practice had worked with the hope that they wouldn't let the practice know that I had an active investigation pending. If that produces something, then I can just sort of follow those trails. And then eventually I'll start talking to active employees of the practice. The biller, I don't often see the biller talk to early on. Sometimes I'll see a record request, but what they do is normally documented on paper. So an interview isn't really the most important thing. If you do have a compliance officer, I would say that individual is probably going to be somebody who would eventually be interviewed. But most of the practices that I've worked with don't actually have an active compliance officer in place at the time. Very rarely will they come out and seek to discuss the situation with the owner of the practice or somebody in charge in the practice, because what they're usually concerned about at that point is triggering them to seek counsel, not making a statement, and then having counsel get involved very early on in the investigation. So just to sum that up, An audit, usually medical records, we're not seeing interviews. If we're closer to criminal investigation, we will likely see some interviews and investigators sniffing around, and that starts with people who were with the practice but are no longer connected.
Great, thanks. Good advice. John Schroeder, here's a question for you. We have only LCDs for DFUs and VOUs. How are these going to be applied for other graft treatments going forward? And I'm sure the rest of the panel will have an opinion too, but we'll let you take a first swing at that.
Okay, so there's a lot spinning around in the woundosphere, right? About, are the LCDs going to go into effect? Will they extrapolate from VLU and DFU and not cover anything that's not a coded VLU or DFU? Are they going to add products? Are they going to get rid of the coverage list altogether? Does the 4 and then 8 applications apply to other wounds? There's a whole bunch of questions, and there's a lot of people that are providing, I think, unfortunately, uninformed or underinformed answers because nobody really has the right answers yet. So I'll start with, are the LCDs going to go into effect? The new LCDs are future effective. So for them to be changed, they would have to enter a new comment period under their normal processes, right? We've seen the government break its own rules before, and there are some pathways that they could do that. So it's likely that if they're not delayed, which there is an active ask and there's a letter circulating around for Congress folks to sign on to, I think there's 9 co-signers now, to delay the LCD so we can get more evidence. But there's a question of also if we're going to be able to add more products onto those LCDs, what is the standard of evidence? And that's been answered in a variety of ways by different folks. From some of the MACs, they say that they can't consider any evidence because they can't add any products. From CMS, they've said that they want RCTs, but will consider real world evidence. And then they've said in other places that they would consider real world evidence if it's backed up by RCTs. And then the other side, you've got the FDA saying with their biosimilars paper the other day, we don't really see the need to have comparative studies within a class like this because they're biosimilar. So if it's sounding like there's a mess coming, there is a mess coming. Both in the PFS and in the LCD, it clearly states that the jurisdiction of the LCDs ends with DFUs and VLUs, and all other wound types will be considered on medical necessity. It says that in the comments. It says it in the LCD. It says it in the comments about the PFS and in the PFS. So we would like to think that the government's going to hold itself to the standards of keeping to their word. However, we've already had some folks contact the Wiser model administrators and have asked the question, what if I, submit, if I'm in a Wiser state, what if I submit a pressure ulcer? And they're going to say, they have responded back that they're not going to approve anything besides VLUs and DFUs. So I'm going to stop there and basically just say that the LCDs are admittedly a mess, and they were put into place as a proxy to slow down money going out of the Treasury. But we don't really need that in terms of a covered list. Group 1, Group 2, Group 3, whatever. They don't really need that to enforce or to try to mitigate payment because of the PFS. I'll stop there.
All right, any other thoughts about the LCDs and other wound types? All right, I've got another one for you, John. Do we expect the January 1st changes to the PFS to be implemented as is? What will stick and what won't?
So the lawyers in the room probably in the context of what's something that could be litigated easily and what we can win on might have some comments to this after my comment. But what I would say is that on November 5th, the PFS, which affects all physician payments, was published in the Federal Register at 127, blocking the entire calendar year 2026 PFS ruling for us is unlikely. Are there other groups that are upset at the PFS? Yeah, there are a lot. There's a lot of cuts in there. What's notable in my mind is that you have to go backwards a little bit. So they took the entire HCTP product line that's out there, 11 billion this year or whatever, and decided that they were going to change those arbitrarily with no authority to incident to supplies like a dressing might be, like gauze might be. And in doing so, they took responsibility in the PFS to actually pay for those without getting any additional funding to do so. So, and they talk a little bit about in the PFS is how they're going to figure that out in 2027. And they're hoping that, with voluntary reporting on the ASP in 2026, they'll be able to crank down the pricing even more. They have an unfunded mandate that they've created for themselves to pay for skin substitutes, camps, out of a bucket that has no money for that, right? So they're going to need a legislative fix, or else they're going to have to slash provider reimbursement for all CPT codes and A&M codes that are in the PFS later. And really, some would say in 2026. So the whole thing with the PFS, in my mind, hinges upon whether they have the authority to make HCTPs not biologics and drugs, which has an unlimited, it doesn't have a budget neutrality standard imposed upon it like the PFS does. And I'm not a lawyer, but that one seems like an opening there. Rumors are out there all over the place that someone's going to sue the PFS on that basis or other bases. I just haven't seen anybody come forward and say, yeah, I'm suing, right? Our position as a company is that the PFS is going to go into effect at 127 January 1st, but that there is a legislative pathway that we can go down and that I'm actively going down along with a lot of other people that would fund it, raise it, deal with some of the issues in the LCDs by calling for an NCD and do a lot of things, right? But right now, I don't think we have any credible evidence that PFS is going to be delayed. And I'll leave it open to the group.
Any other thoughts? All right. I think we're about out of time. This was fantastic. I know we didn't get to everyone's questions. I know we had some questions in the chat today that we couldn't get to, but I still think this was really helpful, hopefully, for the audience. Those of you who need help with an audit or other issue, these are all great experts on this panel that you could tap into depending on what problem you have. So we highly suggest reaching out to them if you need help. I think we've shared all their information in the past, but if there's a specific request and you can't figure out how to get in touch with them, just let Carrie or Alyssa know, and we'll be happy to share contact information. And again, thanks to all of the panelists for participating and for doing the webinars before. I think this was really helpful to the community, so we much appreciate it. And we're planning our next webinar series, and we will let you guys know when we're ready to launch about that. And I hope you'll join for that also. And with that, I'm going to sign off. Thanks.
Well, before you go, Howard, before we all
Yes.
leave, for those of us that are still on the call, if you want to know more about what you can do to change the future, the PFS, the LCDs, you got to get politically involved. Basically, the executive branch agencies, HHS, FDA, CMS, they're full of bureaucrats that are just, pushing things around and redefining things to meet the likings of basically to cut spending. And that's become a big mantra now, is to cut spending. As a matter of fact, last week, earlier this week, CMS put out a notification that they're raising premiums on Medicare recipients, but they would have had to raise them a lot more if it hadn't been for the heroic efforts of CMS to slash spending on these egregious skin substitutes. So on the other side of that, we know that there's no way that the companies that are on the covered list, if that remains, can supply the market, and that at the price at 127, much of mobile wound care is going to struggle to remain in business without a lot of scale. In other words, there might be 3 or 4 companies remaining in a year out of 3,000. And that care is going to be very factory driven, regimented care. So the long story short is we have people that are driving legislation, not the legislation that we've seen already, but new legislation that will incorporate a lot of that and deal with a lot of the problems that the Cassidy bill and the Carter bill do not. If you want to learn more, you got to reach out to us, and we can tell you what we're doing and see if you want to be involved.
And John, I just want to jump in because I really wanted to mention something after your comments, but didn't hit unmute in time. You mentioned that nobody has taken the step to sue yet before the PFS goes into effect. And that's what I'm finding as well. I expected somebody to step up and at least try to file an injunction. I do think that there's a fantastic case for it. I think that the number of people that will be harmed when this goes into effect, the number of businesses that will go out of business, and I think that the lack of available evidence that they made this decision based on, including the fact that we don't have any 351 approved substitutes available that it sort of calls for, that is all looking more towards an arbitrary and capricious application of this. While the law isn't necessarily in the best favor, I think you could probably find a decent judge if a couple of cases were pending. So to that end, I'm just throwing it out there. Some entities got to step up and hopefully get some sort of injunction. The legislative angle is probably the most appropriate and long-standing relief, but temporary relief just to keep people alive while the legislation gets changed, I think is really in order.
Good point. All right. Well, thanks everyone. Appreciate it. Have a great weekend.